Hey everyone, welcome to this week's edition of Title Scoop. So this week we're going to talk about an article that was sent out last week from Alta. If you didn't read it, I would encourage you to. I am going to do kind of the Cliff Notes version today, but I definitely encourage you to read it, and I will put the case citation in the email if you want to read the case as well. So the article was entitled, Ohio Court Holds Escrow Agency May Be Liable for Wire Fraud, Remands for Further Proceedings. So obviously this caught my eye because with wire fraud, most of the cases that come down do not find the title company or escrow company liable. And so when this one was having the potential of liability, I wanted to read and find out what happened. Well, as most wire fraud cases happen, this one is really similar. Buyer's purchasing the property. He actually got notification both from his realtor and from the title company on multiple occasions of what he needed to do to be aware of wire fraud. He needed to call and verify wire instructions independently. And so he'd received this, like I said, multiple times from the title company and from the realtor. So what happened, of course, is 2 days before closing, he receives an email. It's actually from a Gmail account. He did not catch that it was different than the URL he had been receiving from the title company. And he did call and confirm wire instructions. However, he called the number that was on the fraudster's email. So, of course, the fraudster was very kind and went ahead and verified those wire instructions. And the buyer sent his money to the fraudster. We, of course, don't know where that money is. He goes and closes a couple days later, and then the title company notifies him, hey, we never received your wire, and it's discovered that he was a victim of wire fraud. So this one's kind of interesting because, again, the title company, when the trial court looked at it, had really good procedures. They were warning their customers. They were giving lots of notice, email, they were calling, they were talking to their realtors, and the realtors were actually notifying as well. So there were a lot of steps that were at play where they were really trying to make sure their buyers were not victims of wire fraud. Unfortunately, it didn't prevent this one. So what happened is a few months after the closing, buyer decides to sue the title company and the realtor. Now, the realtor was dismissed, as they usually are in these cases, and the buyer alleged negligence, breach of fiduciary duty, and breach of contract. So the trial court actually ended up granting the title company's summary judgment. And basically the title company argued, we didn't owe a legally recognized duty to protect the buyer, and we never agreed to act in a fiduciary capacity. So the trial court agreed with the title company, and then the buyer appealed. So that's where this judgment or this order, I should say, came, as the Court of Appeals looked at the evidence from the case, and they actually decided to reverse and remand. And although, again, it's not to say the title company is going to be at fault, it's just the fact that they looked a little more in depth than some of these. And they basically said they wanted the trial court to get more facts. We need more information, they said, on the breach of contract and the breach of fiduciary duty, so they could make an actual decision. So that's where the case sits now. Again, this is relevant to us because, one, this court is looking a little bit more in depth at the breach of fiduciary duty and the breach of contract to see if it existed. Interestingly, and this was noted in the article, the court did imply that potentially if a lender was involved, this might have been a different outcome. So I don't know exactly what would be at play there that would be exactly different, but maybe there would be a little bit more liability on the lender too. So again, it's relevant here because cyber fraud is crazy right now, right? Every time we turn around, we are hearing stories about wire fraud and different cyber fraud attempts or attacks. And so I wanted to bring it to your attention because it was just a really good reminder to make sure agents have their process and procedures in place and that they're looking at those regularly and knowing what these fraudsters are doing so that they can adjust as well. If you do not have a good process and procedure in place for wire fraud especially, you can look on Alta's website. They have really specific instructions of process and procedures in their best practices section that go over what you can do as an agent to really try to prevent it. Now, again, although we haven't come down as a title company or escrow company with liability, no one wants to be part of a lawsuit. So it's better almost to go above and beyond to try to prevent it so that we don't become part of a lawsuit with a buyer who's lost his money, because no one wants to be part of that. No one wants to see a buyer lose their money. So if you guys have questions, again, let me know. We're going to obviously talk about wire fraud regularly because it's just something that's constantly hitting our industry. All right, with that, we're going to call it a week. We will see you all next week.